So welcome everyone. My name is Josh Adams. I'm from Gilbert and Sackman. I'm the current president of SoCal LERA. It is so exciting to be here for our 39th annual conference. We'd hoped this would be in person, but due to COVID, we thought it would be safer to be by Zoom, but we want to see all of you in person and we want to talk with all of you in person as well. And we think that's going to happen soon. We just have to wait for a good moment. So this conference is brought to you in cooperation with our incredible partner, the National Academy of Arbitrators, the Southern California region, and our longtime supporters at Regions 21 and 31 of the National Labor Relations Board. And I also want to give a special shout out to the FMCS Southwestern region. We are so grateful for all of our partners and supporters out there. Today's program, I hope you'll agree, just has exceptional content. I look at it and I'm intimidated. So if you're not intimidated, you are an august person, truly. It's a really wonderful program, lots of intellectual content. And I think that's one of the hallmarks of this organization and why I love being involved with it. We cast some of the management, employee, labor union shtick aside and really delve into issues as Emily and Bernadette have taught me, with light, but not necessarily heat. For those of you who are new to SoCal LERA, this is the Southern California chapter of the Labor and Employment Relations Association. It was created by the combined efforts, which we always want to acknowledge, of OC LERA, LA LERA, and San Diego LERA to offer programming to all of Southern California. Our organization is open to representatives of labor and management, union officials, attorneys, human resources personnel, neutrals, students, academics, and anyone at all interested or involved in industrial relations, collective bargaining, and other labor or employment issues in the private or public sector. So management folks, employee and union side folks, government agencies, and neutrals and academics can mingle and share viewpoints, which is so important for our profession. Our hallmark is collegiality. I hope you got a sense of that from Juan Carlos's introduction. We really do want to get to know each and every one of you. Become a member, obviously, if you're not, renew your membership. If you haven't, get involved with us, get to know us. We welcome participation from new folks, as well as our friends who have supported us for so many years. Before I get to the brief housekeeping issues, I do want to give a special thanks to Emily Smith and Bernadette Tiemann, who got us set up today, who are helping us troubleshoot problems as they come up and who make LERA run out of the University of Illinois. We're so grateful for you. Last, as I posted in the chat a couple of times, how you logged in on Zoom and your name as you see it before you is how we recognize you for MC Elite credit. If for some reason you don't get an MC Elite certificate from us, for those who want it, in the next couple of weeks, email me directly. My email is in the chat. I'll just say it briefly. It's jadams@gslaw.org. In terms of how questions are going to function throughout today, that will be dependent on the moderator. So the moderator will cue you as to how we're going to do that. For those panels where there are panel materials, you should be able to access them through the SoCal LERA website. Our presentation today, for those portions of it which are recorded, including the speech right now, you can come back and hear me say this again if you want to, as many times as you want. And look, if you want to hear me do this many times, I wouldn't blame you. It just makes sense after what I've said so far. So some of the panels will be recorded, some not, and you'll be able to know that because it will indicate in the Zoom user interface that it's recording. Okay, so with that, I'm going to turn it over to a longtime supporter and good friend of SoCal LERA and its iterations before SoCal LERA, Christopher David Ruiz Cameron, who is the regional chair for Southern California for the NAA in that capacity here today, but also is the Justice Marshall F. Mokum Professor of Law at Southwestern Law School. My apologies if I mispronounced that name. And it goes without saying that Chris is a recognized expert, an absolutely recognized expert in the law of the workplace. And it's my pleasure to introduce him and have him take things from here. You're on mute. Chris, wait, you're on mute. There you go.
Of course I'm on mute. Wouldn't make sense if I wasn't. Thanks very much, Josh. I really appreciate that introduction. Welcome everybody to our Academy panel on the secrets of effective advocacy in labor arbitration. I want to get right to it. The PowerPoint that I'm sharing is in the chat. is available on our website, and you can also email me, and I put my email address in the chat in case you need to get it. A brief word about the National Academy of Arbitrators. We stand for the highest standards of integrity and competence in labor arbitration. Our job is to promote diversity, equity, inclusion, and belonging as part of that mission. Our mission includes educating advocates and the public, and we provide all sorts of reference materials. So we're very happy to participate in this program with SoCal LERA. Our morning agenda is going to go like this. Our Academy panel on advocacy runs from now until 11:45. There'll be a short coffee break from 11:45 till noon. And then the NLRB update panel will run from 12 to 1:30. And then there's a lunch break from 1:30 to 2 before the afternoon program resumes. So that gives you an idea of what you're prepared for today. For the next 90 minutes or so, I want to mention what the topic is we're going to cover, or our theme. I want to discuss the format very briefly. I want to introduce you to our red light, green light panelist arbitrators, as well as our guest arbitrators. Then we're going to take up the red light, green light cases for 45 minutes, and then we'll go to the breakout rooms, in which case you can discuss the cases that have been prepared for that, or whatever questions that you may have for arbitrators as advocates. So with respect to our topic, the theme is when the show must go online, the arbitration of disputes in the remote workplace. All of our hypos have that theme attached to them in some way. And they're all based on recent cases and recent disputes that many of us have heard dealing with online work during the COVID-19 era. We're going to do the red light, green light panel right now until 11. And then we're going to go to the breakout room cases, or the chat as you prefer, moderated by our various guest arbitrators. So let me just mention that when we get to the 11 o'clock segment, that 45-minute segment, the second half of the morning, it may take a few minutes to send everybody to breakout rooms, including our guest arbitrators. So be patient and wait for everyone to assemble. And we're asking people to put their name on the screen as well. And if for some reason you get booted from a room, log on again and you'll get reassigned to a breakout room. So with that, I want to introduce our red light, green light panelists. I'm pleased to introduce, first of all, someone I work with on a number of programs, who's a very hardworking arbitrator and mediator. That's Kathy Fragnoli, who's a member of the National Academy of Arbitrators. Good morning, Kathy. Also, everyone has already met our president of SoCal LERA, Juan Carlos Gonzalez, who's also one of the newest minted members of the National Academy of Arbitrators. So congratulations to Juan Carlos, or JC.
Thank you. Good morning.
Very good. We're also here to welcome Yuval Miller.
By the way, Chris, Josh is the president. I'm the executive director.
I'm sorry, I've got that wrong, of course.
That's okay.
Josh, my apologies to you as president. I want to introduce Yuval Miller, an arbitrator and mediator who's very busy. Yuval is based in Northern California, but he hears cases and mediates disputes all over California, and I think Nevada too as well. So welcome to Yuval Miller. Yuval. Thumbs up.
Thank you very much. Good morning.
Thank you very much. Good. And then finally, my friend and a very hardworking member of the Academy, Ken Perea, most recently the star of the National Academy of Arbitrators annual conference in Marina del Rey last fall. I think Ken set a record by serving on a planning committee for 2.5 years, which is as long as any planning committee has lasted in the Academy. So Ken, welcome to you.
Thank you.
Here's a list of our guest arbitrators who will be leading the discussion in the breakout room starting at 11 o'clock, and I won't name them all here, but we're very pleased to have them. And then several of us on this panel will also be leading breakout rooms. So my thanks to everyone listed here. I really appreciate it. Let's go to our red light, green light cases. And what I'm going to ask the panelist arbitrators to do is to indicate how they're voting by voting, putting up a red symbol if they're voting for the union on the grievance, meaning, or excuse me, the employer, typically meaning that the grievance is being denied. And if they're voting for the union's position, that's a green. And I think all the arbitrators have indicated that they can do that. And I'll ask them to leave their votes up and then to explain them. And then we'll move on to other questions, and I'll ask them to either change their vote or stick with whatever vote that they wanted to make there. So red will be for the employer, green will be that they're ruling in favor of the union. And of course, we're going to find out why. So let's go to our first case having to do with the cancel culture lesson. The facts are as follows. Weedout.com, a website with national influence, provides an online template for high school students who want to weed out teachers who are intolerant due to their anti-trans, homophobic, or predatory nature. During the pandemic, students of the ABC school district using that template posted photos of 4 teachers under the banner, "Why are they still allowed to teach?" And that posting attracted 4,000 likes that were submitted by non-students as well as students. And some of the non-students had graduated from the school as many as 20 years ago. In response, Super, who was the superintendent of the district, conducted an investigation in which 100 of the likers were interviewed. And there's some more facts. The supervisor's final report on the incident, which included video recorded statements of 50 likers, found 4 teachers had engaged in anti-trans, homophobic, or predatory acts. As a result, 3 of these 4 teachers quit or were retired. Only the grievant remained, and he was discharged due to findings that were made in the super's final report. So the union, who represented the grievant, filed a grievance. At the hearing, the district offered into evidence the final report that was prepared by the supervisor, the superintendent, as well as the video recorded statements of 50 likers. None of the likers testified at the hearing. So the union objected on 2 grounds. First, lack of authentication of those statements and the final report, as well as hearsay. So I want you to assume, panelists, that the applicable MOU, like all the collective bargaining agreements that will be mentioned in this panel, require just cause to impose any discipline. Now, here are the arguments. The union argued that the objections to this evidence that was offered must be sustained. First, the district has failed to call witnesses to authenticate the video recorded statements, so it cannot be confirmed who the likers are, whether they ever attended school in the district or had contact with the grievant or any of the other 3 teachers. Second, the union argued that the statements are pure hearsay and likers cannot be cross-examined. Such character assassination should not be tolerated. Third, the union argued that the final report consists of double hearsay because it merely repeats the contents of statements by various folks. And then fourth and finally, if the objection is overruled, then the exculpatory statements collected by the union, they collected a bunch of statements, whether those should be admitted as well. That's what the union argued. If you're going to put their stuff in, we want ours to go into. The district's counterarguments were as follows. The objections must be overruled, first of all, because arbitration is supposed to be informal. So evidence should come in for what it's worth. Second, this evidence is worth plenty. 1 or 2 statements might be ignored, but not 50 statements by these likers. Third, exclusion of these statements would violate the victim's due process rights by denying them their day in court. The likers aren't testifying because they can't afford to travel to the hearing, or they fear the grievant, or they have nothing to add to their statements. And then fourth and finally, live testimony is overrated, according to the district. Video recorded statements can be reviewed and credibility can be determined as if the likers were here in person. So panelists, how are you ruling on this? I'm going to stop sharing the screen for a second. Go ahead and vote. Red is for the employer, green is for the union. So I've got 3 greens, and then Arbitrator Miller, how are you going on this one? Oh, I've got no from Arbitrator Gonzalez.
I'm back and forth. I'm partially yes, partially no.
So we've got 3 votes for the union to sustain the objections. First of all, to the hearsay statements.
Red, just to be clear, red is to exclude, or red is to admit? Red is to admit for the district. So green
Red
is
is
for the
to
union.
admit for the district, correct. Green is to exclude it per the union's argument. Okay, so we've got 4 folks going with the union. Arbitrator Fragnoli, would you start us off here? Why your vote in favor of the union?
I guess my biggest problem is that we don't have any live witness testimony. I don't care if we have 50 or 1,000. We don't have anyone live subject to cross-examination, and that's a cornerstone of litigation, arbitration, anything in our world where you need just cause, you need cross-examination. So that's the biggest problem for me. In the day of Zoom, as we all can see here in our living rooms or our bedrooms, wherever we are, Zoom these people in, pick your top 5, Zoom them in, make them subject to cross-examination. The report is based on what the superintendent heard these people say. So again, there is an authentication issue and the hearsay issue. So that's why I'm voting to have a real trial here, a real arbitration before you terminate someone.
Very good. Arbitrator Perea, what was your thought about that?
Well, I agree with Kathy, of course, but I think the important thing here, since we're talking about secrets, is this is probably one of those questions that you want to know as much about the arbitrator as possible. Those of us who have served as advocates, as attorneys in litigation, recognize that hearsay is very unreliable. And I've had many experiences in that, and also as an arbitrator, many experiences where hearsay has been proven to be unreliable. So to base an important decision on unreliable not even testimony, just unreliable information, is to me contrary to basic notions of justice. And that's why I think it should be excluded.
So thank you, Ken. Arbitrator Miller, you're voting with everybody else. What if, and I want to hear why, but also could you address Arbitrator Fragnoli's concern? Well, maybe you should have called at least 5 of these witnesses. And if so, if the district had done that, would you let in the other 45 statements?
Well, yeah, let me preface this with, I would, for especially people who are representing employers out there, be careful what you wish for. Many arbitrators will allow all of this in and then, subject to arguments as to weight, and then give it no weight. So you're actually being offered a favor here by the arbitrators on the panel who would exclude the evidence because they're sending you a message that you need to put on a witness, and then if you're going to use any hearsay evidence, corroborate that testimony with the video recordings and the other materials. And for example, the superintendent would be called so that he can explain how he prepared the report. I've had many cases where there's a date on a document and it's not actually the date it was prepared, or the person didn't prepare the document, somebody else prepared it and they just signed off, they never read it. So all of these things are important. But you can also get these exhibits in, not as corroboration, but rather as impeachment. So the district could call the grievant or wait until the grievant is called and then present these video recordings and say, well, that person looks, what's wrong with this person's story? Did that happen or did it not happen? And perhaps the grievant will say, well, it didn't really happen like that, and then you get information out of the grievant. But be aware that if you're submitting exhibits and they come in even as to weight or as impeachment documents for the purpose that they come in for. And in that case, in an impeachment situation, they're coming in for the purpose of bouncing off of a witness to see how the witness responds, and the arbitrator is then listening for how did the grievant respond to the impeachment material. It's coming in for the truth of the matter in some way, at least under the federal rules, but I don't think most arbitrators are going to consider what's in the video recorded statements as if a witness is testifying, because there's no cross-examination. So be aware that you can generally raise hearsay, admit hearsay exhibits as impeachment or corroboration. and be aware that you're giving up something by doing so, because if something is not subject to cross-examination, as Kathy pointed out, it's going to be a lot less reliable for the arbitrator.
So thank you. So Arbitrator Gonzalez, we want to hear your thoughts on it. And could you also address the argument that's being made by the employer here in part that, look, this isn't a court of law. This is arbitration. It's less formal. We don't follow all the trappings of the rules of evidence, at least not to the letter. What do you think about that?
You know, first of all, good morning, everybody. Great, wonderful to see everybody for such a great program today. I think my colleagues, I think we all support each other and agree with each other's points. Generally speaking, I would let in the final report simply as that's the document the employer used to determine to terminate the employee. In regards to the 50 video recorded interviews, I would have a lot of problems going down that rabbit hole because you don't have the opportunity of cross-examination. You don't get to find out what the background is. You know, are these all the students that failed out of the class with this teacher? You know, what year were they at the class? You know, to go down that road, I think I'd have a sidebar with the advocates and say, guys, do you really want to go down this road? Because it's going to take us weeks to go through this. So my generalization would be to exclude the video recordings, even though I would let in the final report, and I would definitely exclude the record of all the likes. The reason the employer gave why individuals didn't come to testify is based upon that they were afraid that, you know, it was too far to travel or they didn't have any more to add. That's not enough. Obviously, as Kathy said, Zoom is there. It's not up to them to decide if they've got anything more to say. And the reality is, if you feel that strongly about this, you know, you're expected to show up and testify and be cross-examined. So we need that. Otherwise, this is just not right to go forward and terminate somebody on evidence that isn't provided ample cross-examination. Chris, I'm not sure if I answered your specific question. Did you want to add to that?
I think you did. I was just going to the other questions I had here. I think everyone's addressed both the hearsay objection and they'd sustain it, vote for the union. The authentication objection as well, it sounds like, except for you, Arbitrator Gonzalez, if I got that right, you would have let the report in for what it's worth, the superintendent's report.
Yeah, I think we need it. We need to find out what the employer is thinking, what they based their termination on, not necessarily for the proof of matter asserted, but for, you know, documentation of how we got to where we are.
Now, all of you were pretty skeptical about the employer's evidence, assuming that it came in, that you let it in for some reason, all or in part, like letting in the statement. How do you feel about the exculpatory statements? Arbitrator Fagnoli, what do you think about that?
I can't even get there because I'm not going to let something that's so inflammatory as to affect my judgment on the matter. I'm not going to come anywhere near it. So I don't get to exculpatory evidence.
Is your concern about the character assassination argument, or are you concerned that if you let it in, you're going to be unduly influenced by these statements that aren't tested by cross-examination?
Well, my job's to determine what happened and what needs to happen. And I can't determine what happened from invisible people who I can't see and see under cross-examination and observe and make a credibility judgment on. So, I mean, that's the basis of our job. Otherwise, we could just dial in arbitrations all the time and not have any witnesses. I mean, where do you end there? And to listen to 50 people say the same thing, which I'm assuming they would, nearly the same thing, I don't want to go near that because of the inflammatory nature of it and the possible persuasion effect of it. So
I should have asked for a separate vote here on the exculpatory statements. Is there anybody who would rule for the employer and and let them in? I guess I'll just ask that before I go on.
Wait, you mean for the union?
The union is voting to keep them out. So, oh, excuse me, you're right. But for the union is now offering exculpatory statements from witnesses who aren't going to testify. So would anybody let those in? Go ahead, Arbitrator Miller.
I mean, I would let them in because their impeachment of, you said we're assuming that the other materials came in, the other 100
I think you'd have
video.
That's
Then I would let in the exculpatory statements both. I guess I'm assuming that the grievance is going to testify, and in response to that impeachment evidence that I let in it for impeachment, say, no, that didn't happen the way that person said it, and now you can present the exculpatory statements as corroboration of the grievance negation of the impeachment statements. But we're getting into a bit of a spiral here, and what Kathy said is right on point. If you're keep in mind what you're presenting the statements for, because I'm not going to believe anything that's in these statements. I'm just going to look at them as taking away from or adding to something that ultimately ends up in testimony. So the original statements, they come in. If they're coming in for impeachment, they just reflect on the testimony. These exculpatory statements are then casting doubt on impeachment evidence, and they're very limited use. Yeah, I would let them in if the others come in.
Can I jump in on something?
Go ahead.
I think there's also a major technical issue here, especially since we're doing so many arbitrations on Zoom. And that is, how in the world are you going to get 50 recorded videos to the arbitrator? How are you going to show those? Are you going to sit on Zoom for hours on end showing these 50 recordings? I think that is absolutely impractical. If you've got exculpatory evidence or maybe even supporting evidence for the employer, documented, handwritten statements, it's a lot easier to let them in and, okay, they're in, put them aside, review them, but that's it. I mean, it's going to be a lot simpler to deal with documents than it would ever be for videos.
I'm glad you raised this, and we have to move on, but I do want to ask you, how would you feel about this? What if the advocate for the district said, I'm going to call 3 to 5 witnesses to testify, and they can be cross-examined and whatever, and the rest of these statements, I'm going to send them to you in a zip file or send you a disk or something like that, and you can look at the other 50 at your leisure if they're admitted into the record. How do you feel about that?
I mean, I want to give other people a chance, but since I let in the final report, I'd say, yeah, let's listen to the people who get to be cross-examined. The rest, I'm really not going to bother with. I'm sure the final report has the highs and lows. And, if the 5 people the employer picked aren't the best witnesses, that's really what's going to carry the case, not these other, admission by group, I guess you can say, because you let these 5 witnesses testify, so therefore we let everything else in. I don't think that makes sense. We can't fall to the concept that the more witnesses on one side makes it more true than having less witnesses on the other side. We've really got to be careful with that.
Thank you. I'm going to give Arbitrator Perea the last word on this question so we can move on.
If I could just shift a little bit here. I think Chris, I give you an A+ on this hypo, because it brings up the perennial problem that's been in existence since the beginning. And that is, what if the arbitrator lets it in for what it's worth? What is that going to mean? I don't want an advocate to be surprised when they get the award and the arbitrator took some hearsay that's unreliable and ran with it. So I think it's important to understand, because all arbitrators are not the same. It's important to understand what your arbitrator's thinking is on the question of hearsay. And the best way that I can think of to find that out is the first time the advocate on the other side attempts to bring in hearsay, raise an objection, so you can get a read on the arbitrator's approach. Because if the arbitrator says, I'll let it in for what it's worth, that means I've got to bring in evidence in support of the other side's case that contradicts what the hearsay says. You've got to do that, because otherwise you're leaving yourself exposed.
All the pictures were lined up in a row here.
Oh, I think you need to get a read on the arbitrator. Unless you've worked with the arbitrator before, maybe you may know that information in advance.
Very good. I'm going to exercise the privilege of the chair to assume that on the merits, if this is the case that people are going to put on, that you're not going to rule for the employer. First of all, everyone was skeptical about letting the information in. I do think, though, that advocates should keep the following in mind based on something that Arbitrator Gonzalez said, which is that if your best case is going to be hearsay and double hearsay, some arbitrators are going to call you into the hallway or ask for a separate breakout with the advocates to say, if this is your case, you're probably not going to be very successful, and maybe you guys ought to talk about settling this or something else, because it's not going to go very far. I think that's what some arbitrators would do. I don't know about all this group. I'm going to move on, giving you a little food for thought. We need to talk about a couple other things. Our next case is a Zoomer for happy or unhappy hour. And the facts of it are as follows. And I'm going to ask all of the arbitrators if they could please turn off their red and green reactions for the moment. The facts are as follows. At this employer, happy hour is held on Zoom. Time spent at happy hour is not compensated, but important work-related announcements are sometimes made there. Attendees are mostly rank and file workers, but some supervisors attend as well. Anne, an African-American employee, joined the Zoomer, and her "I Can't Breathe" poster could be seen in the background, presumably in her home. The grievant, a Mexican-American employee, left the screen and went to her kitchen, where she could be heard by others on the Zoom call, saying to her husband, "I'm tired of all this Black Lives Matter bullshit." Nobody filed a complaint, but the grievant was discharged anyway. And so let's just go right to the merits on this. Red is you would deny the grievance. Green is that it would be sustained on behalf of the grievant who was discharged for what she said to her husband that could be overheard by everybody else. So panelists, if you're going to go if you're going to deny this grievance, vote for the employer. Red, green is for the union. I see Arbitrator Miller. Have you voted on this one?
I did.
And I'm looking for the color, but so just tell me.
Green, green.
Okay. Looks like most folks are green. Why are you green, Arbitrator Miller?
I'm green because there on this record, the fact pattern contains no evidence of any policy against political speech. There is no just cause to fire somebody for their political opinion unless there's a clear and uniformly applied policy that political opinions cannot be expressed at work. Note that the "I Can't Breathe" poster is also political speech. If that poster was allowed by the policy, but the spoken words of the other woman were not allowed, the nature of that distinction would have had to have been made clear before this happy hour in the policy or training or practices of the company, such that it was communicated to the workers. The conduct was also off-duty, which means the employer would have to prove nexus, which has 3 prongs, none of which were present here. And I won't go into that now. I don't think that's the main point here, is that there is no policy that this person has violated.
All right, thanks. So Arbitrator Fragnoli, do you agree this is off-duty, and what's the reason for your ruling?
I think it's off-duty enough, and there's probably alcohol involved. So she gets to have her unfortunate belief system. She thinks she's in the kitchen talking to her husband. So I go to intent on a case like this. If she's looking in the screen saying this to the one with the sign, that's different than Ms. fighting words. And so you would look at the case differently, I think. But as written, she's off the hook.
Yeah, so the context is everything in this. The intent was important to you. Does it make any difference, Arbitrator Gonzalez, if the employer has a well-publicized and heartfelt policy about including favoring diversity, inclusion, and belonging, and has promulgated that in a handbook and says, hey, everybody needs to behave themselves, including when we're doing these Zoom chats?
Well, it definitely helps an enormous amount for the arbitrator to have a policy that the employer is claiming has been violated. I mean, most employers are trying to be more diverse, more inclusive. They don't want to create workplaces where people are feeling less than others because of their diversity. So the fact that it's publicized, and depending on who the employer is, maybe they're a pretty well-known employer, it becomes very sensitive. So I empathize a great deal with the employer in this case, but is it enough from what we have in the fact pattern to terminate the employee? I don't think so, given the fact that, maybe if the employee was a supervisor or manager, maybe if they had a background of creating a hostile workplace, maybe they've only been around for a year. I mean, you're always looking at the background of the employee. Of course, you're looking for past issues that they've had in the workplace. But generally, I just don't think it's enough to establish some kind of hostile workplace. Is it offensive? Absolutely. Is it protected political speech? I don't think so. I think the poster would be. I could defer to Erwin Chemerinsky for the constitutional analysis on this, but I just don't think it's enough to terminate somebody's job on a comment like that. She's off camera. Did she say it? Did somebody else say it? It'd be interesting to hear what the union's arguments are on this.
Arbitrator Perea, what's your thought about this? And I'll just throw a curve at you. What if this employee had been warned and maybe given a suspension in the past for 2 other occasions in which she made intemperate remarks in the workplace? Would that make any difference to you?
Well, it certainly might move the ball if you could establish the first part, which is that she's done something which deserves to be disciplined for. And I think we've all kind of hit both points. One is the content of the speech. The second is the context of the speech. Now, I would not go down the road of the content of the speech because it gets a little bit cloudy. Is it politically insensitive? Is it prohibited by the employer? All those questions become a little bit more doubtful. But if you take it just from the context, and I think that's all you need to decide is just the context. She moved to a different room, unless she lives in a very small place. Usually I would think that there'd be a wall or something that would separate the rooms. She's moved from what I view as being a workplace meeting. I do believe that the initial meeting, even though it wasn't paid for, which maybe somebody should be filing charges on to get people paid for being at work. But the initial meeting was work related, but it moved when she moved away from the screen and engaged in a conversation with her husband. It was no longer within a context of a work related discussion. And I think that's all you need to decide. It wasn't work related. And I hope that employees are still, despite all the technology that's evolved over the years, as we've gone on from pagers and going forward, that there's still a modicum of privacy that employees enjoy in their kitchens when engaged in speech with a spouse or significant other. I would hope we haven't gone just completely eroded all rights of privacy. So for that reason, I would say it's not in a workplace context and it should not be a basis for any discipline.
So very quickly, let me ask 2 of you, starting with you, Ken. If this case isn't a basis for upholding a discharge, is there some lesser discipline that should be upheld, such as a warning, for example, or no?
I said it wouldn't warrant a discharge. It's not a question of the degree of the offense. It's a question of privacy rights, the utterance of speech in a kitchen to her husband. Well, unless the employer can somehow establish that her microphone was so sensitive, it could pick up a conversation 50 feet away from the Zoom meeting. Unless the employer can establish that, I think she has every right to expect that her speech would be private, and there's no basis for discipline. End of story.
Let me ask Kathy Fragnoli, who on the intent grounds found that there was no basis for discipline. Does that mean also that you wouldn't uphold a warning or some lesser form of discipline either, or just the discharge?
I wouldn't uphold any discipline, maybe a memo to the group, reminding them that others might hear a private conversation should do it.
So no individual discipline.
No, and there was no complaint here either. I mean, so.
And Arbitrator Miller, does that figure into your reasoning that nobody complained?
To some extent, because this goes to the context. I have to slightly disagree with Ken's point about what she said doesn't matter because it was in her kitchen. If she said, I'm going to take a gun to work and murder that employee that's got the Black Lives Matter or I Can't Breathe poster up, that would be a different situation. And the reason is those three factors that I didn't cite before regarding off-duty conduct. It was off-duty, and the question becomes threefold. Did it cause harm to the employer's interests or the public trust? Second, did it adversely affect the grievance ability to perform his or her job? And third, do other employees refuse to work with the person? I guess if there was no complaint, but she threatened to murder somebody, it'd be a tougher case, but I would assume there'd be a complaint in that situation. And if there were a complaint, it would go towards the factor of other employees not wanting to work with the person. You do have to be careful of what you say off duty to the extent that it has a real and substantial effect on the employer's business.
All right, thanks very much. Let's move on to our third one. This is an iPad timekeeping case. And here, the employer who produces monitoring equipment wanted to switch from paper timesheets to iPads for timekeeping purposes. And all 300 employees in the workforce were given an iPad and trained how to enter their time. The training was effective and the use was simple. And during the transition, employees were directed to submit their time by both paper and iPad. And timekeeping on each system during this transition was audited, and employees with discrepancies were subjected to discipline. The grievant, who happened to be the union shop steward, had some trouble with the iPad system, and Human Resources asserted that he was counseled for several discrepancies, but none of those appeared in his personnel file. So there's some more facts. Meanwhile, the operations lead was rumored to have tested positive for COVID-19, and union members asked the grievant, their shop steward, what was he going to do about it? The grievant twice approached the operations director, who initially walked away and later said he was too busy to discuss it. The next day, the auditor discovered the grievant had entered 8 hours on paper, but only 1 hour on his iPad. The grievant was suspended for 20 days and given a final warning. Less than 1 year earlier, the same grievant had been suspended for 10 days for a verbal altercation with the same operations director over various COVID-19 protocols, and the union grieved. So the employer's argument was as follows: the grievance must be denied and the 20-day suspension and final warning have to be upheld. First, progressive discipline has been applied. The grievant was not only counseled several times for the same offense, but also given a 10-day suspension for the verbal altercation. He gets one more chance to shape up or he's gone. Second, the grievant knew or should have known better. Training was effective, use was simple, employees were on notice of auditing for discrepancies, and the grievant, like all employees, works on monitoring equipment. So the failure to complete the task was his fault and not the employer's. Union's counterarguments were as follows: the grievance must be sustained and the 20-day suspension and final warning put aside. First, progressive discipline has not been applied. The grievance alleged counselings for several prior discrepancies were not documented, so they don't count. And discipline for the iPad offense should not be piggybacked onto a 10-day suspension for an unrelated verbal altercation offense. Second, the grievant is a victim of anti-union animus. He was disciplined 1 day after raising COVID-19 concerns with an unresponsive operations director, who was the same supervisor with whom he had had that verbal altercation over COVID-19 protocols. So panelists, I want you to vote here if you're going to uphold the 20-day suspension and final warning. That's a red vote for the employer. If you want to set it aside, it's a green vote for the union. I'm going to stop sharing my screen for a second and ask everybody to weigh in here. All right, so I have everyone but Arbitrator Perea.
Try again. There we go.
All right. And once again, I have presented an unbalanced problem. So Arbitrator Perea, let me start with you. Why are you voting for the union on this one?
All right, so this is a little more complicated than some of the other hypos that we've addressed because it involves two different issues. One is whether there was just cause. The other is whether there was retaliation due to union protected activity. Now, in the just cause, it's not that complicated because it's really a question of the degree of punishment, in my opinion. I don't think there was the hypo is a little ambiguous because as I read it, I don't think there's any intentional misrepresentation in the paper recording of 1 hour. So I don't think you're dealing with an issue of falsification of company records. So he made a mistake. He's never been disciplined for this type of offense. The coachings are not considered to be discipline. If I were an advocate, I would think carefully about whether I'd even try to make that case, because the more I struggle to make the case that the counseling should somehow weigh in the arbitrator's mind as to the degree, it looks weak to me, in my opinion, as an arbitrator. So I don't think I would bring it up. If I think I have a strong enough case, I wouldn't even bring it up, but it sounds weak. So it's really a question of the degree of the punishment and the fact that he's had a prior offense for which he received a suspension for 10 days. It's such a different, some offenses can be argued to be somewhat similar. And this is so different. One is actually his workplace performance, his competence. The other involves an issue of insubordination. So completely different. So I think while it should weigh, the prior discipline should weigh, it's not entitled to great weight because it's such a much different situation. So he made a mistake. I think this is a situation where that calls for more training and not severe discipline. And the problem is it's severe discipline, even though it's still a suspension, but he's just, a hair away from being fired because he's been given a final warning. So
if it was no final warning, what if it was just we're elevating this to a 20-day suspension?
That makes it a little closer, but I think, Chris, it's still excessive, in my opinion. But this is not something that's black or white, or it's not science. It's one's opinion. But I think based upon the nature of the offense, a mistake, an honest mistake where there was no intent to falsify records, he just didn't have the skill in that particular instance to execute it properly. And he should be given some form of mild discipline, maybe a written warning and retraining. If we have any respect for him as a worker and think that he should be, his employment is worthwhile to the employer, he should be given a chance to correct this deficiency.
Thanks.
Now, I don't know if you want to go into the second issue. That's a much more difficult.
In the interest of time, I'm going to ask you to hold that thought for a second, and let me ask Arbitrator Gonzalez if he agrees or has a different view.
I agree practically word for word with Ken. I would simply add that if the employer wants to establish a connection between the two different tracks of discipline for the verbal altercation and this iPad violation, I just think they have to prove that there is some type of intentional insubordination, some type of, there's just acting that he doesn't know when he really does know. I mean, I think we see it a great deal on Zoom. We see very experienced advocates who are really challenged by technology. And so it wouldn't be an automatic, it wouldn't be automatic to assume that this person is, intentionally not wanting to learn the iPad. And so I'd have the tough time with that, and the employer would have to work pretty hard to establish that connection. But other than that, I agree completely with Ken.
So let me go to an arbitrator who works on an iPad all the time. Arbitrator Fragnoli, what are your thoughts about this?
I think I would tell the advocates I'm coming in biased because I couldn't even figure out where my green button was here. But if this guy's trying to steal time, he's a terrible thief. I mean, why he's put 1 hour somewhere and 8 the other? I mean, was he there or wasn't he there? So I don't think he needs discipline for that. He needs to learn how to press his buttons on his iPad better. It looks retaliatory. He's mouthing off about COVID-19 and safety issues. It looks retaliatory. If they haven't documented his prior discipline and counseling, my rule is if you didn't ink it, you didn't think it. So again, even though I came from the management world before an arbitrator, I'm going union on this one.
Very good. And Arbitrator Miller, we're going to give you the last word on this iPad.
There's not much I can say that hasn't been said, but I would like to frame a couple of things in a little more detail. And one of them is the question of coachings or counselings that are not disciplinary. They can serve as evidence that the employee received notice of what the rule is. However, and especially here, given the lack of evidence of intentional refusal to use the iPad, I would reduce the discipline because it's not progressive. And on that point, progressive discipline, Ken alluded to this. Progressive discipline means notice and a chance to correct a deficiency. This is the first time grievant is being disciplined for the deficiency of not following timekeeping protocol or anything related to that. So the penalty should be consistent with the penalty that is appropriate for a first offense because there hasn't been a chance to correct that deficiency.
I think it's fair to say that all of us are going to be concerned about an attempt to impose discipline for a different type of offense than the other one, the altercation with its other complicated issues about whether that's retaliatory or not. And that has some overtones here. That definitely complicates things, but having the physical altercation and having this, what might be considered either insubordination or perhaps incompetence, it's a different type of offense. And so you have to be careful about trying to piggyback the discipline and call it progressive based on what's happened in the past. We're just about out of time here. So what I want to do, panelists, if you don't mind, quickly on hypo case number 4, I'm not going to go through the whole thing, but if you've thought it through, regarding the teacher in the XYZ school district, I asked you if you would deny or sustain the grievance, and the grievance related to a discharge for an intemperate remark that this teacher said when they're picking up their child at a school, different school in the same district. So if you wouldn't mind just voting on this, would you deny the grievance, that's a ruling for the employer, or would you sustain the grievance, ruling for the grievant and the union? And just really quickly give us your votes on that, because we need to move on to our breakout sessions. I'm going to stop sharing. And I see Arbitrator Fragnoli's voting for the employer, so is Arbitrator Gonzalez. In fact, everybody is. Arbitrator Fragnoli, if you wouldn't mind just telling us what your views are very quickly on this.
My decision on this would have been about 2 pages. In today's world, you do not talk about putting a pipe bomb in a school because, as we know, these things are threatened and then happen in today's world. And the fact that this teacher or this person put it on the PTA Facebook page kind of makes it school property. It elevates the offense here. So unacceptable, gone.
Thank you. And I'm going to give Arbitrator Miller the last word here because we need to move on.
All right. Well, I went over the nexus factors earlier. The employer showed a nexus here because allowing a teacher who makes threats about bombs to continue working would damage the district's public function, role models violence to the teacher's own students, interferes with the teacher's ability to do his job, and threatens other teachers and administrators.
All right, very good. Well, thank you, panelists. I appreciate all that. We're going to now move on here. I'm going to put up the screen for what we're going to do. We're
Thank you,
moving to
everybody.
our breakout room sessions where you can either discuss the cases on the PowerPoint or just have whatever chat you want with the arbitrators. It's going to take a couple minutes to make sure that guest arbitrators are in all the breakout rooms. So join me in thanking the red light, green light panelists, and we'll see you in the small group rooms. We're going to go to that just as soon as we can. Thank you, everybody.
Thank you, everybody. Great seeing everybody. Thank you, Chris.
Thanks, everyone.
Kathy.
Bye.
Thank you, Yuval. Thanks, Ken.
Thank you.